I know there's been some, well, I'm not going to go there. I'm going to let Mr. Leach, Representative Leach, go there. But members, today, individuals with severe mental illness can be sentenced to death. The U.S. Supreme Court has ruled that the current protections for individuals facing capital punishment are founded on the idea that individuals who fail to understand their actions or why they are being punished are not fit to be sentenced to death. The exemption created under this bill focuses on, it only applies to 3 persons. It applies to a person who has schizophrenia, schizoaffective disorder, and or bipolar disorder. If a person is found guilty, they will receive life in prison without the possibility of parole. Again, a person will still be punished. That person just will not be sentenced to death.
Mr. Slayton, for what purpose?
Mr. Speaker, does the representative yield for some questions?
Sure. Yes, Mr. Speaker.
The lady yields for questions.
Thank you, Mr. Speaker. Representative Rose, so this bill is going to allow mental health, which is not medical science. Mental health, which is observational based.
What?
It's going to allow those factors to determine if someone, let me back up here. Are you aware that there's medical science and then there's mental health, there's observational science?
I'm not aware of
It's
that.
based on observation. A psychologist will sit and talk with someone, and they make their determination by a discussion, by observing. They're not doing a medical test. If you have something wrong with you medically, right, you would take a test, and of course, in a criminal case, you would have a forensic scientist determining the cause of death and what was used, and then even doing fingerprints to determine who did it. That could be medical tests. But mental health is going to be observation. The determination if someone is mentally ill, there is not a test to give someone that's reproducible. Are you aware of that?
No, I'm not aware of that.
There's been shown in 2018, a study by the Secret Service National Threat Assessment Center, that 33% of mass shooters have schizophrenia and bipolar disorder, the illness that your bill includes. Is it true that in your bill, potentially 33% of these heinous mass killers could be exempt from capital punishment?
Mr. Slayton, let me explain to you what my bill does, because apparently you have a total perception of what my bill does. This bill is on a case-by-case basis, and it only applies to persons with 3 mental illness. The 3 major severe mental illnesses, which is schizophrenia, schizoaffective, and or bipolar disorder. Now, I don't want to get into debate with you about science and this and that. You read my bill, and I understand you probably have orders to come in here and try to disrupt the bill, but I've explained to you, and we've even had a conversation offline just a few minutes ago. So I don't know what you're trying to accomplish, if you're trying to get the group, the chamber riled up about it, or what. If you're going to vote no against the bill, vote no.
Thank you for that. I do have questions, though.
But I just answered your question a few minutes ago.
Ma'am, you just said 2 of the items in your bill, 2 of the qualifying items in your bill were listed by the Secret Service National Threat Assessment Center that 33% of mass shooters have schizophrenia and bipolar. And you're going to give people 33% of mass shooters.
The chair will remind members who are at the back mic to ask questions of the author, not make statements.
Okay. Okay. So,
move past.
So if your bill passes, would it be true that potentially 33% of these heinous mass killers could be exempt from capital punishment?
That's not true.
It's not true?
No, that's not true.
Okay, is it true, is it not true that under your bill, we would determine whether or not someone has murdered who has murdered dozens of children, for example, is eligible for capital punishment based on observational and uncertain methods?
That's not true.
So what tests are they, can you help us, what tests do they give people to determine if they have these, if it's not based on observation and psychological methods and questions, appointments? How does that happen? What test?
It will be the same test they use post-trial.
What is that test?
It's a psychiatric evaluation, sir.
Okay. Now, are you aware of the case of the Hillside Strangler in the late 1970s?
No, I'm not aware.
Okay. So in the late 1970s, these two people murdered people, and in the trial...
That's not a question, Mr.
I'm
Slayton.
asking my question. These two, you said you weren't familiar, so I wanted to make sure you knew about it, and then I was going to ask. So in that trial, this person that was on trial for murder, he fooled 4 experts that he was multiple personality disorder. So now, are you aware that according to the study by the National Library of Medicine, 17.5% of criminal defendants were able to avoid going to prison by convincingly faking mental illness? Are
No,
you
I'm not
aware of that?
I'm not aware of that.
The following amendment, the clerk read the amendment.
Amendment by Tinderholt.
The chair recognizes Mr. Tinderholt to explain the amendment.
Thank you, Mr. Speaker. Members, my amendment, I think, is pretty simple. Anytime
Mr. Leach, for
someone...
what purpose?
Mr. Speaker, I'd like to raise a point of order on this amendment as it's not germane to the bill.
Please bring your point of order down front. Mr. Leach raises a point of order against further consideration of the Tinderholt amendment, amendment number 1 under Rule 11, Section 2 of the House Rules of Procedure on the grounds that the amendment is not germane. As introduced and reported from a committee, the bill covers a single class of persons, those who are unable to form the requisite mental intent for the commission of a capital offense. The amendment addresses a separate, distinct class of persons, those who, with malice or forethought, committed a capital offense. These two classes are not the same, and for that reason, the amendment is not germane. Accordingly, the point of order is well taken and sustained. The chair recognizes Mr. Leach to speak in favor of the bill.
Thank you, Mr. Speaker. Members, I don't want to belabor the point, but I do want to take a second and tell you why I am not just voting yes on this bill, but proudly supporting this bill. There's been some misinformation that's been sent around this morning, and including a letter that was placed on your desk. And for those members who might be new to the chamber, you should always be wary when any group leaves a letter on your desk but doesn't testify against a bill in committee. And I believe that group and those groups, as much as I respect them today, are misled themselves on the bill. I am a supporter, a strong supporter of the death penalty. I believe that in Texas, we need the death penalty and should utilize the death penalty in the most heinous cases. But I am, as a supporter of the death penalty, against executing people who at the time of the offense had a severe mental illness. And that is well-established constitutional law, and other states are passing this law, and it's time for Texas to do the same. We should not, especially as pro-life conservatives, execute people who did not have the requisite mens rea at the time of the offense. Period. We can't do that. And for those of you who might believe that we can and should do that, if you're in the business or if you're interested in saving taxpayer dollars, this bill will save the state of Texas millions of taxpayer dollars every year. Because whether you know it or not right now, the state of Texas is litigating these matters on nearly every single death penalty case, every single one of them. The reason that we have some death row inmates who are sitting in solitary confinement for 23 and a half hours a day for, in many cases, 10, 20, 30, 40 years is because these issues are being tied up in our courts. Good lawyers on both sides are fighting these out, and the state of Texas, through our Attorney General's office, is being forced to show up to spend hundreds of millions of our taxpayer dollars fighting these issues. And what this bill does, all it does, is it requires this determination to be moved, if the defendant so chooses, from the end of the trial to the beginning of the trial. That's it. This decision can be made at the beginning of the trial can proceed, and if it was determined that the defendant who committed the offense had the requisite mens rea at the time of the offense, then that defendant can be executed by the state. If not, then they can't, but they could still get life in prison without parole. I believe this is a good bill that law and order, death penalty supporting Republicans and Democrats should vote for, should proudly vote for. And I think I hope that you'll put all the misinformation aside and cast your yes vote for this bill today.
Mr. Slayton, for what purpose?
Mr. Speaker, does the gentleman yield for some questions?
The gentleman yield for questions.
Yes.
The gentleman yields.
Thank you, Representative Leach. Thank you, Mr. Speaker. Representative Leach, so what misinformation are you referring to exactly?
Well, the information that was provided to members that I've seen is that this bill is an end around to do away with the death penalty. That this bill is some part of a concerted, secret effort to ultimately do away with the death penalty in Texas. And I'm telling the members here, if that were the case, I would not vote for it. And I, in fact, as a death penalty supporter, I believe that passing this bill strengthens the utilization of the death penalty in Texas, not weakens it.
Okay, and in 2018, the Secret Service National Threat Assessment Center, they determined that 33% of mass shooters had schizophrenia and bipolar disorder. Were you aware of their research?
Yes, I am, Representative Slayton, and I'm also aware of the fact that those issues right now in every single death penalty case are being litigated. This bill does not change that at all.
I understand, but if this bill passes, then according to this research, 33% of people that commit a mass act of violence are not going to be eligible for the death penalty because it says 33% of them had schizophrenia and bipolar disorder.
That is patently not true, Representative Slayton. That is absolutely not true. What this bill sets up is a process by way where the judge can make this determination, can hear evidence. Representative Slayton, realize that in this determination, in this hearing before a trial, both the defendant and the state of Texas get to put on evidence. If the judge makes the determination, then the trial goes forward. Nothing about that changes in this case.
Okay, were you aware of the study I referred to? The National Library of Medicine said 17.5% of criminal defendants were able to avoid going to prison by convincingly faking mental illness. Were you aware of that study?
Representative Slayton, I was not aware of that specific survey or whatever it is you're talking about, but I do trust our judges, and I do trust our judicial system to make those determinations. We as the legislature are not here to make those determinations. You either trust our judges and juries or you don't, and I do.
Well, the issue is with the experts or the psychologists, psychiatrists who are evaluating these criminals. It's them that are being fooled, and of course, judges, they have to make their decision. This is about, they've been able to fool experts to avoid going to prison. So that's no small number, 17.5%.
Representative Slayton, with all due respect, that is just a fundamental misunderstanding of how the process works. At the end of the day, the defendant can, and right now does, and will still be able to present whatever evidence he or she wants, period. Can use whatever medical test he or she wants to get or not. And then the state, Representative Slayton, gets to do the same. If the state wants to offer controverting evidence for any of the experts, if the state wants to discredit any of the defendant's tests, any of the defendant's evidence, just like right now, they still get to do so, and this bill does not change that in any way.
Thank you, Representative Leach.
Thank you. Members, I encourage you to vote yes on Vice Chair Rose's bill and to do so proudly.
The question occurs in the passing and engrossment of HB 727. Mr. Slayton has requested a record vote. Record vote has been granted. The clerk will ring the bell. Show Ms. Rose voting aye. Mr. Goldman voting aye. Show Ms. Slauson voting nay. Show Mr. Patterson voting nay. Of all members voting. There have been 84 ayes and 61 nays. HB 727 is passed in engrossment.